Our topic of the week, coming and going rule. What are we talking about there? Well, many folks are confused as to whether or not their injury at work is going to be considered a workers' compensation claim or not, because they clocked out or they weren't clocked in yet, and so they're not entirely sure where to file the claim. Do they file it under their health insurance? Do they file it under an accident policy, or do they file it under their work comp policy? And if you have a good understanding of the coming and going rule, you will take your facts of your particular case and apply it to the coming and going rule and determine whether or not it's going to be a work comp claim or health insurance policy or some other type of accident claim. Just because you are clocked out or you haven't clocked in yet doesn't mean that the accident or accidental injury isn't work-related. The first thing you have to understand is that if you are on the premises of the employer and that premises is exclusively controlled by the employer, then you have a workers' compensation claim. So that's the first thing to understand when you're stuck in a situation where you're not sure, well, I haven't clocked in yet, but I'm on the threshold of the employer. Are you on the employer's property or are you on somebody else's property? You need to make that determination first. The second thing that you need to look at is a much more complicated rule, and it's basically a rule involving whether or not the route that you took to the employer, whether that's a walking route or a driving route, is the only route that you could take, and it is or has a peculiar hazard with respect to the route, or it's the required route by the employer and you suffer a work-related accident. If it's the only available route and it falls within all of the conditions for that as set forth within the statute, then you may have a work-related accident. Again, remember, you don't necessarily want or need that if you have good health insurance. You need to look at the totality of your circumstances to determine whether or not you want to file a workers' compensation claim or leave it under health insurance or some other disability or insurance policy. Anytime you have one of those situations where you're not sure if it's the exclusive control of the property is with the employer, or you have a situation where you're not sure whether or not you're on a route that's going to be controlled by the employer and has a peculiar hazard with respect to your employment, you want to talk to a workers' compensation lawyer before you make that decision as to how you want to submit it. Now, beware, if you submit it to your health insurance company and you make certain admissions in that statement, you may be bound by those statements or admissions. And if in fact it turns out to be a work comp claim, you could be a loser on both counts. The health insurance carrier could deny it because it should have been covered by work comp, and work comp could deny it because of your statements. So be careful about what statements you make or how you submit the claim to the insurance carriers before you make your final decision. And of course, I always advise folks in this situation where you're not sure, you're coming or going here, you're not sure if it's covered by work comp or not, talk to a work comp lawyer first before you make any or take any steps. Now, if the employee's injury is due to the employer's negligence and you're on the way to work, the statute as I read it here, and I had to reread it again recently because there's a lot of ambiguity within the statute. It seems to suggest that if the employer is negligent, even if you haven't clocked in and even if you haven't gotten to your place of employment, if the employer was negligent in causing your injury, then you may have a work comp claim even if it doesn't appear or seem to be a workers' compensation claim because you're not at work yet, you're not assuming your duties of employment yet, but your employer was negligent in causing your injury. You may want to evaluate what type of negligence case you may have, and you may opt to go with a negligence claim versus a workers' compensation claim in that event, or it may be that the workers' compensation claim is the better type of case to have in your situation. Talk to a lawyer who can handle both of those particular types of cases when you're in that particular predicament. And lastly, if your work involves travel, or in other words, travel is an intrinsic part of work. It can't just be that you have to drive to work for it to be a part of your work. It must be something that you do every day as a part of your employment. For example, a door-to-door salesperson, travel is intrinsic or a significant portion of your job duties. Another delivery person is another example where travel would be intrinsic. Oil field workers are often injured driving to and from their employments, and those, generally speaking, are considered work comp accidents as well as negligence claims in when or if there is a negligent automobile accident to look at. So the last point I'm making is that even with some of the new changes in the law, we still have the situation where if travel is an intrinsic portion or part of your work, your work is defined in part by the nature of the travel that you do, then even if you're just coming or going from a particular assignment, you are considered in the course of your employment, and you will be covered by workers' compensation coverage. You don't really need to know for certain. All I will tell you is that you do need to get a consultation with the lawyer anytime you have one of these particular types of accidents where you're not absolutely certain whether or not it is part of your employment contract or part of the obligation of the employer to provide you with workers' compensation benefits. And that is the topic of the week.